seated, please. We have three cases on the oral argument docket today. They will be heard in the order in which they're listed. Of course, your dockets will indicate that the first case, WHI, has been rescheduled. So the initial case is Winn-Dixie Stores, Inc. versus Reddick and Stokes.
Thank you, Your Honor. May it please the Court. My name is Eric Holzhauser. I represent Winn-Dixie Stores in the first appeal with the firm of Kaufman, Coleman, Andrews, and Grogan in Jacksonville, Florida. The issue...
You want to reserve time?
And I'd like to reserve 3 minutes for rebuttal, please.
You need to watch when your light changes. That means you're into your rebuttal time.
I understand that.
Okay.
The central issue in this appeal, Your Honors, is whether or not a multiplier, a 2.0 multiplier, is available in a Florida Civil Rights Act case. Here, the lower court awarded a 2.0 multiplier in granting a motion for attorney's fees to the prevailing plaintiffs below. The first thing to analyze is the applicable attorney's fee statute. And that, the Florida Civil Rights Act of 1992, mandates that fee awards be awarded in a manner consistent with federal case law involving a Title VII action. That makes this attorney's fee provision unique in Florida as compared to any other attorney's fee provision that I've seen. It expressly incorporates by reference federal case law under Title VII. If you look at the lower court's opinion, there's absolutely no mention of that, no analysis of federal case law under Title VII. Instead, the court below looked at the Quanstrom case and really focused in on awarding a 2.0 multiplier under what the Category 2 of Quanstrom. As you may recall, Quanstrom divides attorney's fee cases into three categories. One, public policy type cases, which they expressly said included discrimination cases, and this was an age discrimination case. Category 2, applicable to contract and tort claims, where they said a multiplier up to 2.5 would be available depending on the contingency risk in the case. And the third case is trust, eminent domain cases, which are not at issue here. Anyway, in looking at this case under Quanstrom Category 2, our position is that the court erred. That when you look at Title VII case law for attorney's fees, nowhere in Title VII is there anything similar to Quanstrom Category 2 in terms of awarding attorney's fees. One of the cases that the lower court cited was a Florida Human Rights Act case that predated the Florida Civil Rights Act case. But again, that law didn't have the reference, incorporating by reference, Title VII case law. And so our position, that does not apply at all. Rather, we look at Title VII case law. And when we look at Title VII case law, the issue is very clear and simple. The 11th Circuit Court of Appeals, as other courts of appeals have done, has held that a multiplier is not available at all in Title VII actions. The McKenzie case followed a United States Supreme Court, Daigle versus Burlington, which held that under a fee-shifting statute like Title VII's, in fact, Daigle specifically mentioned Title VII, that there was no no multiplier or enhancement available under those statutes. That is the law under Title VII. And I think my opponent doesn't even argue that currently Title VII law does not allow for a multiplier in a discrimination case. The argument from the other side is simply that Daigle and its progeny weren't decided when the Florida legislature enacted the Civil Rights Act of 1992. And that you look at the law back then, not now, when we're deciding whether or not to apply a multiplier. Well, I think that argument fails for several reasons. First of all, under the pre-Daigle Title VII case law, it wasn't settled that a multiplier was available. Certainly nothing along the lines of the Category 2 Quanstrom case that the lower court relied on. And I think the better position would be that the Florida legislature, in incorporating by reference Title VII case law on attorney's fees, meant to even the playing field between going to federal court under Title VII or state court under the Florida Civil Rights Act in terms of attorney's fees. That attorney's fees wouldn't be the determining factor of which place the lawsuit was filed. A couple of...
Counsel,
Yeah.
so under your argument then, if the federal courts determined that there were no attorney's fees at all to be awarded to prevailing plaintiffs in a Title VII action, then in state court those plaintiffs would be entitled to no fees, right?
Well, not exactly, because under the federal law we have an attorney's fees statute, which is just like the Florida Civil Rights Act attorney's fees statute to the prevailing party. And they'd have to amend the statute to eliminate the statutory provision for attorney's fees to be able to make that ruling. And I think that would change the context of it. Federal Title VII case law has always involved an attorney's fee shifting statute, just like the Florida Civil Rights Act.
So the statute, the federal statute, is mandatory that the prevailing plaintiff obtain fees, because in the state statute it actually says the court may.
Well,
in its discretion.
the federal court, the federal statute reads the same way, but the way the federal courts and the United States Supreme Court have interpreted that is basically that prevailing plaintiffs automatically get attorney's fees. Prevailing defendants have to prove that a case was frivolous or it was continued to be litigated beyond the point where it was apparent it was frivolous to get attorney's fees. So there is a different standard. It is a may in the language is the same.
So then I guess I go back to my original question, if I may, and that is, when the legislature enacted this section, assuming arguendo, the plaintiff had a right to a multiplier, at least an argument for a multiplier, on the day the governor signed this bill into law. 7 days later, the federal courts take a 180 direction and say, no, you don't get a multiplier. And I know it's probably not likely to happen, but if we interpret the statute the way you urge, then if the federal courts tomorrow say, no, plaintiffs, prevailing plaintiffs in an age discrimination case are not entitled by right to a fee, and in fact a trial court can deny a prevailing plaintiff a fee shifting award, then under your argument, prevailing plaintiffs in age discrimination cases under state law would be not entitled to attorney's fees.
I would agree they would have to follow federal Title VII case law, because the Florida legislature specifically says we're incorporating federal Title VII case law because they didn't want plaintiffs being better off or worse off. Because under the prior law, it wasn't clear under the Florida law whether or not a prevailing defendant would automatically be entitled to attorney's fees just like the prevailing plaintiff. So they wanted to even the playing field. And of course, I don't think my opponent would argue that they don't get the benefit of federal Title VII case law, that it helps the prevailing plaintiffs. But I think the idea is it evens the playing field. If we have over here where you get a 2-0 multiplier if you go to state court on the FCRA, and you don't get it if you go to federal court under Title VII, you can imagine that there will be no cases filed in federal court because of the attorney fees provision. That if a plaintiff's attorney could get double his attorney's fees in one form over the other, that's going to flood the state courts with discrimination cases. But there's other reasons beyond just the intent of the Florida legislature to even the playing field on attorney's fees. But it's true also that Title VII didn't automatically allow for a multiplier before the Daig decision, which came out 7 days after the Florida Civil Rights Act was passed. The case that everybody looks at before Daig was a Clean Air Act case called Delaware Valley 2, Pennsylvania. And it said, it is a plurality opinion, there were 4 justices that ruled that no multiplier was available as a matter of law in that case. A concurring opinion by Justice O'Connor, which said in that case there was no multiplier available, but there could be in other cases. And that is the case that sort of spawned not settled law that a multiplier was available or enhancement was available under Title VII, but it spawned there was some unclarity in the law that the Daig court confirmed. In fact, in Delaware Valley 2, the plurality opinion specifically first says, we conclude that multipliers or other enhancement of a reasonable lodestar fee to compensate for assuming the risk of loss is impermissible under the usual fee-shifting statutes. it went on to say that even if it were available, in dicta, it said even if it were available, there might be some circumstances where you could award up to a third, but no more. And then Justice O'Connor said there were circumstances maybe where you could have some enhancement of the fee. But what's interesting in Delaware Valley 2 is they didn't remand it back for determination whether attorney's fee multiplier would be available in that case based on some litigation over whether or not you needed an enhancement to attract attorneys. They just reversed and ordered no multiplier. So the impact of that decision was no multiplier under federal fee shifting statute. That was adopted under Title VII, and the Dade court simply confirmed the plurality's initial position that no multiplier is available under the usual fee shifting statute. And if you look at the case of King versus Palmer, which is a case out of the Circuit Court, District of Columbia, that goes through a very careful analysis of why even before Dade, Delaware Valley 2 did not provide for a multiplier or enhancement in a Title VII case. And it clearly goes through a very careful and thorough analysis of how the court cannot conclude that there's a multiplier available, even if there's some evidence that plaintiff's attorneys would turn down the case if they didn't have a multiplier. The court there correctly pointed out that if it's hard for an attorney to argue after they've taken a case with no multiplier guaranteed that they're entitled to a multiplier to attract them to take the case they've already brought to the appellate court. So it really made clear that there was no multiplier available even before Dade under Title VII, and cases did follow that. And the two cases that my opponent cites from the 11th Circuit upholding a multiplier in Title VII cases, in both cases the appellate court pointed out specifically that the defendants below didn't argue that enhancement was not appropriate, that wasn't an issue that they brought up in the lower court. So that they waived their argument there, and the 11th Circuit simply confirmed what the lower court had done based on that waiver. So our position is Dade didn't change the law. Dade simply confirmed what the law really was before the Civil Rights Act was passed. There's nothing in the Civil Rights Act that says we incorporate Title VII law only that before the law was passed. And it simply would, I think, create an uneven playing field if in one court you can get double attorney's fees, in federal court you can't. I think that would put stress on the Florida legislature to fund state courts more when they're already overburdened, and I think that's something that the Florida legislature didn't intend to do when it tried to conform the Florida Civil Rights Act attorney's fee provision to the federal law. And I think I'm into my rebuttal time, so I'll stop for now. Thank you.
May it please the Court. They're in this field of statutory interpretation.
Do you want to reserve time for rebuttal on your cross appeal?
No, sir. I believe they've stipulated to the issues on cross appeal. Okay. So, in the field of statutory interpretation, there's absolutely no method by which a court can conclude that a legislature enacted standards, willfully enacted standards, of which it had it was in complete ignorance of the meaning of those standards in the future.
You don't think the legislature ever makes a mistake in their language and the courts say that this language means something different than what the legislature intended it to mean?
Certainly, but that's not the case in this case. What happened here is the Winn-Dixie's position is the legislature gave away its ability to change the standards for fees in civil rights cases, gave it to the federal government. And the Florida Supreme Court has said not only is that impermissible, it's unconstitutional. It's an unconstitutional delegation of legislative authority for the Florida legislature to cede that authority to a federal agency, the Congress, or the federal courts.
It certainly isn't improper for the legislature to say that the attorney's fee, right to attorney's fee, which is a substantive right, will be equal to the same substantive right that litigants would have in federal court, is it?
Perhaps not, except if the state, I think it actually may, because it could say that the standard shall be interpreted in a liberal fashion. The courts can come back and say, we're going to interpret this in the same manner as cases have been interpreted as to Title VII in terms of the intent of the statute. However, with regard to a standard, a particular standard that's being created for attorney's fees, which was done in this case.
Doesn't the essence of your argument, though, depend upon us accepting that the rule had changed?
Yes, and it has.
I mean, well, why, I mean, you know, the Supreme Court isn't making it up, right? I mean,
No, it did.
They're interpreting Title VII, aren't they?
It established 40 years of established case authority with regard to contingency fee multipliers. And in fact, my opponent...
Diggs overrules cases?
Yes, it does.
And it specifically says it overrules cases?
It does. And what also happened is prior to Day, interestingly enough, it was enacted on January 27th of 1992. Counsel cites one case out of the D.C. Circuit that said fee multipliers were not available. It's the only case to rule such. The American Bar Association, American Law Institute, published on June 17th, 1992, the same day that this legislation was signed into existence, a treatise on recent developments in the law of attorney's fees, citing what had happened pursuant to Delaware Valley II. And in each and every case cited, contingency fee multipliers were granted. The only exception, the lone exception of all those courts, circuit courts, district courts, was the case cited by my opponent.
Counsel, you, Mr. Delagold.
Yes, sir.
You made a bold statement there at the beginning about this interpreting this statutory provision in a manner consistent with its plain language, quite frankly, I think you might concede, would constitute an unconstitutional delegation.
Yes, sir.
Did you make that argument in your brief?
No, Your Honor. We argued vehemently in the brief that as a matter of statutory construction, a court cannot interpret a statute with regard to another body's, another set of case laws interpretations. Could not leave that to another entity. The Florida Supreme Court in Freemuth v. State, and we did not cite Freemuth in our brief, but we did cite the concept.
Yeah, and that's my concern is I actually think the delegation argument is something presenting an interesting argument. I'm wondering if that delegation argument was made below. I quite frankly don't think it was made in your brief.
Well, sir, frankly, what we had to do is most of these arguments were made in the reply brief. We did not have an opportunity to respond to most of the arguments made by Winn-Dixie. We did state clearly in our brief that as a matter of statutory construction, we cited numerous cases for this proposition. A legislature may not cede its authority, may not allow another state, the federal government, another entity to determine the future standards which will apply.
So in other words, in your argument then, what the legislature should have done in the fee statute is say, not it is the intent that we cede our authority to the federal courts, but they could have simply stated in the statute, no multiplier shall be allowed. They could have said that, right?
They could have done that.
Right.
But what they did is they froze in amber, in essence, the state of the case law as of that date. Because, frankly, your questions were good ones. What if the courts, the federal courts tomorrow said the Christianberg standard no longer applies? Prevailing defendants may receive attorney's fees. That's not a matter of statute. That's a matter of federal judicial interpretation. And if, just as in Day, the U.S. Supreme Court reversed that determination, my counsel would say, even despite the fact that legislative history specifically refers to Christianberg, counsel would say prevailing defendants get fees.
So your position, though, is if there's a federal appellate court that rules that there's a multiplier available prior to the legislature enacting this, then there is a multiplier available for all time, correct?
Unless the legislature changes the statute.
So even if the Supreme Court comes along and later says that appellate court was wrong,
right,
it doesn't matter. That appellate court, and if there were two different appellate courts and one said a multiplier existed and one didn't, what's the rule then?
Well, I think at that point what the courts have to do is take a look at the U.S. Supreme Court, which stated in the concurrence that there was a multiplier available. And every other federal court that addressed this issue, except for the lone case that my opponent cited, said that a multiplier was available.
But all those federal courts, I mean, when the Supreme Court comes out and says this is the way it is, then
and
that
they
is
reversed 30 years of precedent.
But not their own precedent.
Yes, they did. They reversed because clearly in prior cases, the U.S. Supreme Court had granted the issuance of multipliers, upheld the issuance of multipliers in a variety of various cases.
But your argument, counsel, as I take it then, and I'd like to hear a little bit more about the delegation argument, is that provision that says, I mean, we're bound by the statutes to the extent the Constitution allows. Your argument, I take it, is that provision that says it is the intent of the legislature that federal case law control has to be completely ignored. That's an unconstitutional...
Until the date they cited it.
If I may. That's an unconstitutional delegation.
Right.
I'm going to go down this road with you analytically here. That's an unconstitutional delegation. The legislature cannot cede the state sovereignty to the federal courts, so we go back to a court may, in its discretion, award a reasonable fee.
Well, Your Honor, respectfully, what the cases say on delegation is they say a legislature can adopt case law or precedent of a foreign jurisdiction up to the date that it is enacted.
Right, but it can't.
It can't cede that authority for future changes in the case law.
So can you pursue that a little bit then? Since I didn't have the benefit of it previously, the Supreme Court, you say, has binding precedent.
Yes, sir.
That this court cannot honor a legislative declaration that federal case law in futuro will control our decision.
Exactly. No more than this court could permit the legislature, the Florida legislature, to say, we're going to let the future decisions of the legislature of Georgia affect the interpretation of our statutes. And
the legislature, I know this is repetitive, but in your view, what the legislature was required to do in that fee statute is say, multipliers are or are not allowed. Federal case law up to this date is adopted.
Right.
To that extent.
And not just multipliers, also prevailing parties fees, fees for fees issued. My counsel has conceded that fees for fees are awardable under Title VII and therefore awardable in this action, and they certainly were awardable as of the date of the passage of the statute. Instead of going through all the various rules, the legislature in 1992 froze in amber the interpretations that had existed up to that date. They could not say, we're going to go with whatever the U.S. And frankly, the reason for this is clear, because Florida has repeatedly adopted a contrary view from Dake. Dake says that contingency fee multipliers are not necessary to preserve the public interest. The Florida Supreme Court in Sarkis and Roe and Quanstrom and all these cases have repeatedly said, we disagree. And frankly, virtually every other state in this nation has disagreed with Dake, especially with regard to civil rights statutes. It is the policy of the state of Florida that fee multipliers should be available in these types of cases. That's contrary to the policy in Dake. The Florida legislature could not have anticipated that. There were some...
if I may, you go ahead.
I was going to ask you again. I mean, so if a statute, if everybody believes, and even the Supreme Court believes, the statute means one thing, and then later the Supreme Court comes along and they look at the same statute and they say, you know what, we reevaluated, it doesn't mean that, we were incorrect.
They were not interpreting a statute. They were making a policy argument. The Florida U.S. Supreme Court made a policy argument that multipliers were not available. They did not interpret a statute. They made it in Dake. They said, we do not need fee multipliers because this is not in the public policy of the federal court system.
So in your case, though, as I recall, your billable hours in this case were 1,100?
I believe so. Yeah, it was a huge amount.
Right.
It's an enormous amount.
And the trial court record was, and the order was, quite detailed regarding your success and your efforts, not to mention the testimony. But with the multiplier, your fee is approximately $400,000.
Yes, sir.
Instead of $2. So that's $400 an hour,
yes,
approximately.
Sir. Yes, sir.
And so under Quanstrom, your argument, if we get past this intent statutory language, is that that's a reasonable fee.
Yes, sir.
And what category under Quanstrom is your case?
It could be fit under either Category 1 or Category 2, pursuant to this court's ruling in the Weaver case. It's both Category 1 and Category 2. And the findings in this matter, the trial court made detailed findings. Further, the record shows clearly there were, in the whole metropolitan area of the city of Jacksonville, there were 2 attorneys, hypothetically 3, who could have taken this. Of the 2, one refused to do so because unless these clients paid him essentially $250,000 on a pay-as-you-go basis. The other one was me. And frankly, my contract, which is in the record, shows that I clearly contemplated the availability of a contingency fee multiplier. It's in the contract. And counsel makes the argument that this is going to flood the state courts with litigation. Frankly, fee multipliers have been established by this court since 1993 in Weaver. And we haven't seen a flooding of the state court system with these types of cases. In fact, I did a count, and since that time, there's under 100 reported cases in the Florida courts over a 12-year period, 13-year period.
Now, if we rule in your favor, we're going to have to say, in an opinion, that the legislature is without the power to adopt in futuro, as I stated, case law controlling the definition of a reasonable attorney's fees.
Well,
essentially, we'll have to interpret that provision in that manner.
You'll have to interpret that provision in the way that every other single court in the history of time has interpreted similar provisions, which is no legislature can cede its authority to some other body for future interpretations of a statute. That's what you would have to do. And you would have to say to the state legislature, if you want to change the method, you can say it can be, you can change it right now. You can change it and say, you can change it to incorporate the state of Title VII case law as to attorney's fees as it exists in 2007. But you can't let it change after the fact. I want to say briefly a couple other things on cost. I think that issue was fairly seated because of the new, first of all, Title VII, as the cases that I cited state, includes cost in the definition of attorney's fees. And counsel cited the language of the statute that says fees are part of cost. Dowdell, which is a leading case, 11th Circuit case, 698 Fed 2nd at 1190, and that is in the brief, but this portion of it is not in the brief. Other cases are. Reasonable attorney's fees under the Act must include reasonable expenses because attorney's fees and expenses are inseparably intertwined. Further, the new fee guidelines, the new cost guidelines that were adopted by the Florida Supreme Court are procedural in nature. Courts have already ruled that those are procedural in nature. The estate of Court v. Broward Sheriff, which is a 4th DCA case, dealt with the restriction on reimbursement for expert witness fees. And in that case, it ruled the statute unconstitutional because the statute intruded upon the Supreme Court's ability to determine cost.
Counsel, can you give me the site again on the delegation case you rely on in the Florida
Yes, sir.
Supreme Court?
Freemuth v. State, 272, Southern 2nd, 473. It cites a 1945 case as well, Florida Industrial Commission v. State.
Excuse me, did you say Freemuth v. State?
Yes, sir. Freemuth v. State.
That's a criminal case, correct?
Yes, sir. The other case is a civil case. The site is 21 Southern 2nd, 599.
So that's been a law for a long time in your view.
Yes, sir, and it's still good law. It's been reinforced a number of times if you look at in the cases subsequently. Thank you, and I appreciate your time.
First of all, as you pointed out, the constitutional issue was not briefed in the court below, or in this court, and we haven't had a chance to respond to it. But let's just rewind back to when the Civil Rights Act of 1992 was passed. The law still was in our favor at that particular point in time, regardless of what subsequently happened. Daig did not change the law. And contrary to what my opponent said, Daig did not reverse prior precedent. The prior precedent...
Would you concede that the prior precedent was unclear?
It was clarified. But here, and just something that I think is a key point, as I pointed out earlier, the plurality opinion in Delaware Valley 2, which preceded the Civil Rights Act of 1992, concluded that a multiplier was not available. Their initial conclusion was that. In 1990, when the Florida Supreme Court looked at that case in Quanstrom, The Florida Supreme Court specifically said, with respect to Delaware Valley 2, citing the plurality opinion, it is evident that the use of the multiplier has been substantially restricted, if not eliminated, by this decision. So the Florida Supreme Court itself recognized that Delaware Valley 2 possibly eliminated the use of a multiplier. The Florida legislature knew of Quanstrom before it enacted the Florida Civil Rights Act of 1992.
Isn't that a pretty good argument that really the legislature should decide on what standard it wants to apply in an attorney's fee statute and state the standard rather than ceding authority to federal case law, which may not have even been clear in 1992?
Well, but it did that. It said we're looking at Title VII case law because, like I said, they didn't want, I don't think, attorney's fees to be the controlling factor in which court you go to. And what we looked at here in the D.C. Circuit case, it's the only appellate decision in between Delaware Valley 2 and this other. But if you look at it, it's the only case that has a careful, lengthy, clear analysis of this particular issue, finding no multiplier. Thank you.
Thank you, counsel.